Hello and welcome to Books for Beneficiaries. My name is Pete Williams, the host of the program on which we talk about the beneficiaries of estates. So much attention has been focused on the owner of the estate, and often the beneficiaries get cast aside, and they have rights and they need information. And I'm hopeful that this channel will provide some of that information. So today I want to talk about the probate process, which is a big subject. It will probably take me 3 or maybe even 4 episodes to cover it very well. And the first segment of this talk about probate is going to discuss, hey, how did I get here? How do you get into probate? First of all, what is probate? Well, probate is a court supervised process for handling the transfer of assets and is the estate of a decedent onto beneficiaries. Now, I'll mention here that probate is actually something more than that. It actually includes the cases of incapacity. So there is a whole nother subject matter of conservatorships and guardianships and that sort of thing. But I'm going to focus on are those estates wherein somebody dies and the estate is passed on to beneficiaries. It is a court supervised process, which means judges and attorneys and hearings and notices and all that good stuff, and a lot of time. It takes a lot of time to get through the probate process. In probate, there is somebody in charge, and that is either an executor or administrator. Executor is somebody who's named in a will. So grandma writes up a will and says, when I die, I want my daughter to be the executor of my estate and handle the transfer of assets. When there is no will, or when the person named in a will is not willing or able to serve in that capacity, then it's generally called an administrator. So when somebody dies, the first thing one does is look for documentation. And if there is a will, then the executor goes out and hires an attorney. And the attorney provides legal services during the process. There are assets that pass to a beneficiary without the need to go through the probate process. And there's several of those. Assets that are held in a trust. A lot of people create revocable living trusts for the very purpose of avoiding the probate process. There's a beneficiary designation in that trust, and by virtue of that trust document, there is no need to get a court order or go through probate to prove up the trust document. A second type of asset that does not go through probate are assets in joint tenancy. Now, this is a little bit different than a beneficiary designation because joint tenancy is actually a transfer of ownership. When you arrange a joint tenancy with someone else, you are actually giving up ownership rights in that property. But nevertheless, their surviving joint tenant takes sole ownership of that asset without the need to go through probate by virtue of being a joint tenant. Yet another set of assets that are not probated are pay on death or transfer on death accounts. Or a POD account is a bank account in which the owner of that bank account has gone in and designated in writing to the bank that, hey, when I die, give this account over to my son, Joey. So mom dies, Joey comes into the bank, has a death certificate in hand, a certain amount of time has passed according to state law, and the bank hands over the money to Joey, and without the need for a probate, without the need for a court order. So likewise with TOD accounts, these are brokerage accounts, stock and bond accounts, where the owner of that account has gone in, signed paperwork saying, when I die, transfer these assets to my daughter, Vicky. And sure enough, when that person dies, the brokerage firm will transfer those assets over to Vicky. There's also something called a transfer deed, where you can transfer real estate by naming a beneficiary. That's not available in all states, so I'm going to skip that for right now, and we'll talk about it in a future episode. And life insurance contracts and annuities have a beneficiary designation. Likewise with retirement plans. There are named beneficiaries on individual retirement accounts, 401ks, 403bs, and other types of pension plans. And when the owner of that plan dies, there's no need to probate it because there's a named beneficiary. And with all beneficiary designations, there's often a named contingent beneficiary in case the first beneficiary is deceased before the owner. So the rightful beneficiary comes in, proves up their identity, and proves they own the asset, and the institution just hands over the funds to the named beneficiary. There is another way to avoid probate. It's normally called a small estate exemption. And that is if the estate is so small, the probate estate is so small that there's no need to go through all this huge process of probate to get something transferred. What is small differs in each state. It could be $1,000, it could be $200,000. Different states have different ideas of what is small and what should be avoided in probate process. Now, if all these things above, the trust, the joint tenant, the pay on death, all that good stuff is executed properly, they will not be included in the probate estate. And these will not be the reason you're in probate unless they are incorrectly executed. How do you get there? Well, one way to get into probate is by doing no estate planning whatsoever. And that sadly is somewhat common, where people simply put off making a decision. It could be for any number of reasons that they hold off. It could be that they're struggling with who to leave assets to. The second reason that I have found is that people procrastinate because people think about their mortality. They don't want to think about dying and death. It's sort of a morbid subject, which they are correct on. Because there's nothing in writing, we don't know what the decedent wanted with their estate. Who did they want to give it to? So they make presumptions. Each state has their own rule, but very commonly it's what I have here. It's some sort of family tree of succession. Husband dies, typically goes to surviving wife. Some jurisdictions, they says it goes to the wife and the children. If there is no surviving spouse, it goes to children in equal share. It often goes per stirpes. And a good example of that, let's say I have 3 children and I've done no estate planning. Well, if a child dies before I do, and they leave 2 children, so I have 2 grandchildren, those 2 grandchildren step up into the shoes of the predeceasing child. So the 1/3 of the predeceasing child goes to the grandchildren, and so they get 1/6 each, and then the other 2 surviving children get 1/3, 1/3. So per stirpe just simply means that when a beneficiary dies, their children step into their shoes, into their position as to inheritance. And then there's a whole list, and it's somewhat typical. If there's no spouse, no children, it goes up to parents. If no parents, then it goes to siblings, and if no siblings, nieces, nephews. And so it's probably what you might think is a logical family tree of succession of interest when somebody has not made their own desires known. Now, there's another way to get into probate, which might surprise you, and that is by drafting a last will and testament. A will is a written document that makes your desires known as to your assets when you die, and it's specifically a request to go through probate. And importantly, it is only as to the probate estate. Remember, we talked about earlier assets that do not go through probate when there's some sort of beneficiary designation, a POD account, a joint tenancy arrangement, a beneficiary designation on IRA. Now, normally the beneficiaries are the same. The beneficiaries in the last will and testament are the same as the POD accounts and the designations of life insurance and the designations of IRA beneficiary. People sometimes forget to change their beneficiary designations. So it could happen that what's in the will is very different than what's on pay on death accounts, transfer on death accounts, joint tenancy arrangements. Sometimes joint tenancy arrangements are set up as a convenience for check writing for an elderly person. And when that elderly person dies, those assets go to the surviving joint tenant. They don't go in accordance with the will. So this can be a big mistake. And this is why sometimes people will choose to go to an attorney to get things done properly. So, as I mentioned, a last will and testament is often simply a typed, signed, and witnessed document. In some states, it is also notarized uh, to prove up the witnessing of that will. It can be handwritten in most states. This is called a holographic will. So a will can be written on a back of a napkin, for that matter, but it can be written on a piece of paper, signed and dated by the decedent, and that's a perfectly fine will. As long as it has all the elements, names an executor, names where they want assets to go, it can be easily probated. Uh, the idea here is that it is the handwriting that proves up the testator's intent. We don't need witnesses. We have the handwriting. Now, sometimes, of course, the handwriting needs to be proved up to prove that it is, in fact, the decedent's handwriting. But as long as that is the case, then it's a perfectly fine will. Verbal wills, well, not so much. Verbal wills are accepted in 3 states, I believe, and they're even when they're accepted in those states, they're very restrictive as to what they control, how much they control. Often do not include real estate transfers. So verbal wills are problematic. You might think you're a beneficiary of a estate based on what someone said, and you might be sorely disappointed. You have an elderly man that says, "Joe, you've been so great to me. You've been so kind. I'm going to leave my estate to you." Well, Joe, you might have a problem in proving up if the decedent really wanted you to have that estate. The law says he would have written it down. He would have put it in writing. A verbal promise is very hard to prove up in court. So we have no estate planning, and a last will or testament will get you right into probate. So another way to get into probate is if you have an estate plan that was originally designed to avoid probate, but there's something wrong with it. And that could be there's a mistake, there's undue influence, or a lack of mental capacity by the signer. So let's just go through those real quick. Mistakes, it can be anything. It could be a wrong name, wrong state, wrong form. Any kind of mistake might need to be corrected in the probate process. Another example of a faulty estate plan is where there's undue influence. It happens. Grandson comes into grandma and says, "Look, grandma, if you don't sign this, I'm not going to take care of you anymore. I'm gonna do something that forces grandma to sign." The estate plan could be unwound. Another example of a faulty estate plan is where there's a lack of capacity. And this sometimes goes along with undue influence. When there's a lack of capacity, when somebody doesn't have the mental capacity to sign a document, they don't know what it is that somebody puts it in front of them and they say, "Sign here," having no idea that they're signing documents that give their estate away to certain beneficiaries when they die. If that can be proven, that person, the decedent, didn't have capacity when the document was signed, it does have to go through the probate process. So another way to get into probate court in which you have an otherwise perfectly fine estate plan that avoids probate, typically it's a revocable living trust that avoids probate, is you could have a contested asset. So whereas above I was talking about the plan itself being faulty, now I'm focusing in on the asset, that there's something wrong with one of the assets. A common example here is where a piece of real estate should have been deeded to the trust. So the example is this: you're going along with your trust administration, no need for probate. The trustee just starts handing out beneficiary inheritances, and they come across the real estate, but there's a problem. On the county records, it shows that the decedent owned the property outright. And yet you've got a trustee that's trying to either sell the property or give the property away. So you can imagine if you're a title company, you say, wait a minute. the title insurance company says there's a gap there. It's in the name of the decedent, but a trustee over here in the trust is trying to transfer it. We got to fix that. There's a gap there. So you have to go into probate court to make sure that that property is properly recorded into the name of the trust so the trustee can handle it. Very common. In many states, it's a much more simplified process, probate process, to get the property over to the trust. But nevertheless, it does happen. So the other thing I just want to mention is that we've got 50 states in the union. There is something called the Uniform Probate Code that a minority of the 50 states have adopted in whole. So each state essentially has their own rules, and you've got to follow the rules of the state. Generally, it's the state of the decedent or where property is located. There can be a difference sometimes. All right. What are the disadvantages? I mentioned that some people try to avoid probate. They try to make beneficiary designations. They try to create living trust so they can avoid it. And to be sure, there are disadvantages to probate. One is the expense. It tends to be very expensive. There is an attorney that's hired, and they get typically a statutory fee that's built into the code. There is an executor or an administrator that gets paid. There are the court recording fees. There's all kinds of fees. Probate takes a lot of time. It's almost designed to take time because they want to make sure that the beneficiaries that are going to inherit property are the proper beneficiaries. There will be plenty of time for people to come into court and stake their claim, and that includes possible beneficiaries, creditors, and state and federal taxing authorities. You lose control in the probate process. And what I mean by that is that the probate process takes over. Yes, you've got an executor, possibly an administrator. Yes, you have an attorney, but you have to do it all in accordance with the process. The fourth item I have here is that there is a public record in most states, and that means that records are going to be available to the next door neighbor, to the local newspaper, to the national newspaper, to anybody who wants to go down to the probate court and look into the file. Are there any advantages to probate? Well, I can think of one, and that is that there's some certainty to a court order in probate. The probate process is lengthy, it's methodical. They have hearings, people come forward, they stake their claim, other people argue against their claim. So that whereas the process is arduous, there is some certainty about it with the outcome. So when that hammer goes down and the judge says it is so ordered, you have some comfort. And now court orders are appealable, but that's sort of rare in probate court. So you have that certainty that creditors have been paid, that taxman's been paid, that all the beneficiaries are known, that there's not going to be somebody coming forward saying, hey, I was a long lost son. They had an opportunity if they were noticed. That finality of probate is something of an advantage. I just want to say that in winding this little episode up, that these comments are simply general in nature and not intended to be tax, legal, or investment advice. I'm hopeful that this program would help you hire the proper tax, legal, and investment advisor. That is not me. And please know that this is just for general information purposes only, not specific legal advice. All right, so that's the episode on probate. How did I get here? In my next episode, I'm going to do the next logical subject matter, and that is, hey, what's going on here? So if you happen to be involved in a probate process, God bless you. I know it's cumbersome. It's confusing. So now that we know how we got there, let's talk about what goes on during that probate process. So until then, I'll see you next time. Thanks very much. Enjoy your week.